Welcome to Supreme Court Oral Arguments and Opinions. This is where we break down the court's most significant actions with analysis you won't find in headlines. In today's episode, I'll take you through a data-driven look at where the court stands this term, share insights from last week's opinions, and then discuss two major cases the Supreme Court just agreed to hear. Cases that could reshape constitutional litigation for years to come. I spent considerable time this weekend crunching numbers on the 2024 term, so this episode will be more stat-heavy than usual. But these statistics tell an important story about how the court operates and what we can expect in the coming weeks. As always, if you find this analysis helpful, please take a moment to subscribe, rate, and share. Let me start with the docket tally because it sets the stage for everything else. By my count, the court heard 62 unique cases this term. The court has decided 41 of those cases, leaving 21 cases still awaiting decision. In percentage terms, the court has rendered opinions in about 66% of its cases, with roughly 33% remaining pending. When I say unique, I count consolidated cases only once. For example, I count Trump versus CASA, Trump versus Washington, and Trump versus New Jersey as a single case since the court consolidated them. This timing matters because June typically brings the court's most consequential decisions. The 21 remaining cases likely include some of the term's biggest rulings, which means we're heading into an intense final stretch. Now let's dive into what happened last week and then explore those two major cases the court just agreed to hear. The Supreme Court handed down 6 opinions that day, continuing the remarkable patterns we've been seeing this term. Here are what I call my 6-pack of observations from this batch of decisions. Observation number 1. Unanimity reigned supreme. Let's begin with the obvious. Continued unanimity. 4 of the 6 June 12th cases were 9-0, with the other 2 cases shaking out at 8-1. When you look at the past 2 weeks together, something remarkable emerges. 9 unanimous decisions and 3 8-1 splits out of 12 total cases. That's extraordinary consensus for the modern Supreme Court, which often splits 6-3 or 5-4 on major issues. You actually have to backtrack 15 opinions to find an opinion with more than 2 dissents. That would be the May 22nd 4-4 per curiam affirmance in the Oklahoma statewide charter school board. Vigis Drummond consolidated cases. Looking at the full-term data makes this pattern even more striking. 29 out of 41 decided cases have been unanimous or near unanimous. That's 71% consensus. The court has handed down 24 outright 9-0 decisions, with Justice Kagan leading the way by authoring 6 unanimous opinions. Justice Alito, Justice Jackson, and per curiam decisions each contributed 3 unanimous cases. By contrast, close counts have been rare this term. 6-3 decisions just 2 times, 5-4 decisions only 3 times, and 5-3 decisions just 1 time. Part of the near unbroken consensus may be explained by the kick-it-back approach that Ms. Blatt brought up in oral argument during the AJT case. More on this in observation number 5. Observation number 2. Opinion assignments tell a story. Here's something that might surprise listeners. 8 of the 9 justices wrote at least one majority opinion across these past 2 weeks. The only justice who didn't get a majority opinion assignment was Justice Kavanaugh. But Kavanaugh had written the sole majority opinion the week before, so every justice got their turn at bat. Looking at the broader term data, Justice Kagan leads in majority opinion authorship with 6 cases, followed by a remarkable cluster where 6 justices each authored exactly 4 majority opinions: Alito, Barrett, Gorsuch, Jackson, Sotomayor, and Thomas. Chief Justice Roberts and Justice Kavanaugh trail with 3 cases each. If you recall from last term, Chief Justice Roberts wrote several end-of-term blockbusters. We'll see if he does the same this term. Focusing back on the June 12th decisions, the most intriguing subplot for writings may have been Justice Thomas joining Justice Jackson's concurrence in Parrish. 2 justices from opposite ends of the ideological spectrum finding common ground on protecting prisoners' rights to appeal. Observation number 3. Speed suggests strategic docket management. What stood out here is how quickly these decisions came down, just 6 to 10 weeks from oral argument to final opinion. That's remarkably fast for the Supreme Court, where cases often take months to percolate through internal deliberations, draft exchanges, and revisions. Rivers took 10 weeks from argument to decision, while Parrish and Zook each took only 7 weeks. This rapid turnaround suggests these cases weren't internally contentious and likely represents the court's effort to clear straightforward cases quickly, preserving time and judicial energy for the more complex constitutional battles still awaiting decision. Consider the contrast. While these June cases moved swiftly, United States v. Scrimetti, the case challenging Tennessee's ban on gender-affirming medical care for transgender minors, has been pending since oral arguments on December 4th, over 6 months ago. Hewitt v. United States and Stanley v. City of Sanford have been waiting since January 13th arguments. Hewitt involves the question of whether the First Step Act's reduced drug sentences apply when someone gets resentenced after the law's passage. Stanley asks whether former employees can sue under the Americans with Disabilities Act for discrimination regarding post-employment benefits they earned while working. Stanley's disability discrimination issue may be moving toward resolution, given the court just decided 2 cases in recent weeks involving the ADA or employment. However, Scrimetti's delay reflects not just its hot-button subject matter but also administrative whiplash. After oral argument, the Trump administration asked the court to dismiss the case because the DOJ now takes the position that Tennessee's law doesn't violate equal protection. This position contradicts the Biden administration's position, a position that caused the Department of Justice to intervene in the case in the first place. Observation number 4. Uncle Sam had a bad day, while individual rights won the day. 5 of the 6 cases involve citizens fighting various government agencies, and Uncle Sam lost most of these battles. We had FBI raid victims against the federal government, a disabled student against her school district, veterans against the Benefits Administration, a prisoner challenging federal appeal procedures, and a taxpayer fighting the IRS. The pattern here shows the court prioritizing cases where individuals were seeking redress against institutional power. Only in Rivers v. Guerrero did the government side prevail, where the court actually made it harder for prisoners to file successive habeas petitions. Despite all these cases involving government defendants, the individuals largely came out on top. The FBI raid victims can now proceed with their lawsuit, disabled students get the same legal protections as other discrimination victims, veterans will receive broader retroactive benefits, and prisoners get procedural relief when appealing. The only exception was Rivers, where the court affirmed stricter standards for habeas corpus petitions, essentially making it harder for convicted prisoners to challenge their convictions after already losing once. Observation number 5. The court as error corrector. Here's the most striking statistic. The Supreme Court vacated or reversed lower court decisions in 10 out of 12 cases over these 2 weeks. That's an 83% reversal rate, which is considerably higher than the overall term percent of about a 66% reversal rate. The justices operated almost exclusively as a correction service, fixing what they saw as errors by circuit courts across the country. This reversal rate isn't unique to this term either, at least as of recently when the Supreme Court grants certiorari, odds are they took the case to vacate or reverse. What's particularly interesting is how the court often vacated with specific instructions for lower courts to follow, like a teacher guiding a student without giving away the complete answer. But this approach has its critics, including lawyer Lisa Blatt, who argued the AJT case and made a blunt plea during oral arguments.
And if you just say, and I know it's sometimes easier for you to say, we don't have to do a lot, but you're caused real harm to the parties who don't have Supreme Court counsel and lower courts who get confused when you just remand and say, we just remand. So if you could at least set the slate free, well, it is part of your job, Justice Kavanaugh, to set the law sometimes. And I understand it's easier for you and you have a lot going on not to set the law.
Ms. Blatt was essentially telling the justices that their job includes setting clear legal standards, not just pointing out errors and leaving everyone to guess what comes next. This kick-it-back approach may explain how the court achieved such remarkable consensus. It's easier to agree that lower courts made procedural errors than to wrestle with the thorniest substantive questions. Observation number 6. Roberts. 41 cases, 41 majorities. Earlier in the pod, I said I spent far too much time analyzing Supreme Court data. Well, let me share this nugget I gleaned. Across all 41 decided cases this term, Chief Justice Roberts has joined only majority opinions, 0 concurrences, 0 dissents. Contrast this with the court's more independent voices. Justice Thomas has written 5 dissents. Justice Gorsuch has penned 4 dissents, including both dissents from June 12th. Justice Jackson has authored 3 dissents while joining a 4th. This pattern suggests that this term, Roberts may be choosing to let other justices speak or prioritizing institutional unity over individual constitutional philosophy. However, as stated above, Roberts may be reserving his voice for end-of-term decisions where his voice may matter most. That's my 6-pack of observations from June 12th. With roughly 21 cases still awaiting decisions this term, we can expect several more batches of opinions before summer recess. We'll see how these trends shake out as we receive more opinions. Let's segue to the Supreme Court, June 16th, 2025 order list, specifically on the two major cases that the court agreed to hear. 1. First Choice Women's Resource Centers in Key. Petitioner versus Matthew J. Platkin, Attorney General of New Jersey. Case number 24-781 and 2, Chevron USA Incorporated, et al. Versus Plaquemines Parish, Louisiana, et al. Case number 24-813. Both cases raise fascinating questions about when federal courts can step in to protect constitutional rights. The First Amendment battleground. The first case involves First Choice Women's Resource Centers versus New Jersey's Attorney General. What stood out here is how a simple government subpoena triggered a complex jurisdictional battle that reached the Supreme Court. Here's what happened. The New Jersey Attorney General sent First Choice Women's Resource Centers a subpoena. First Choice operates faith-based pregnancy centers. The state wanted documents about potential consumer fraud violations, charitable organization issues, and professional licensing problems. The subpoena demanded sensitive information, donor identities, medical claims on websites, and operational practices. Now here's where the story gets interesting. First Choice had until December 15th to respond, but just 2 days before that deadline, First Choice filed a federal lawsuit. The organization completely bypassed the traditional route of challenging the subpoena in state court. Instead, First Choice went straight to federal court seeking to block enforcement entirely. The federal district court said, "Not so fast." The court dismissed the case as unripe. The judge reasoned that First Choice faced no actual injury because New Jersey issued a non-self-executing subpoena. Think of this type of subpoena as having no immediate teeth. The Attorney General cannot impose penalties without first going to state court for an enforcement order. Meanwhile, New Jersey did exactly that. The Attorney General went to state court seeking enforcement. The state court granted enforcement but called First Choice's constitutional arguments premature. The state court told both sides to negotiate the subpoena's scope. After the state court enforcement order, everyone agreed the federal case was now ripe for review, but the federal district court again dismissed the case. The court found First Choice still faced no actual threat of contempt. First Choice appealed to the Third Circuit. A divided panel affirmed dismissal. The majority found the constitutional claims unripe based on case-specific factors. But Judge Bibas dissented, arguing the case was indistinguishable from Americans for Prosperity Foundation versus Bonta, a Supreme Court case that protected donor privacy. First Choice argues federal courts are split on this critical issue. The Fifth Circuit categorically bars challenges to non-self-executing subpoenas before enforcement. The Ninth Circuit allows challenges when plaintiffs show objective chilling of constitutional rights. First Choice claims the subpoena already chilled First Amendment association and speech rights. Donors submitted declarations showing reluctance to contribute due to disclosure fears. The organization argues forcing constitutional claims into state court creates a preclusion trap, where state court adjudication bars later federal review. New Jersey fires back on multiple fronts. The state argues no real circuit split exists because the Third Circuit's decision was fact-specific. New Jersey points out the state specifically disclaimed seeking information from donors who submitted chill declarations. The state court repeatedly declined to order document production and instead directed good faith negotiations. The Attorney General argues the Third Circuit properly applied ripeness doctrine. No state court order required document production. The parties were negotiating scope limitations. The evidence of chill came from donors not even covered by the subpoena. World War II contracts meet climate litigation. The second case takes us back to World War II. Chevron versus Plaquemines Parish involves whether oil companies can remove climate litigation to federal court based on wartime contracts. Here's the backdrop. Louisiana parishes sued major oil companies, Chevron, ExxonMobil, Burlington Resources, seeking damages for alleged environmental harm to the Louisiana coastal zone. The parishes claimed decades of crude oil production damaged their communities. The oil companies tried removing these cases to federal court under the Federal Officer Removal Statute. This law allows federal court jurisdiction when private parties act under federal officers. The companies argued their World War II contracts to supply high-octane aviation gasoline to the federal government triggered this protection. The procedural history reads like a ping-pong match. District courts granted motions to remand, finding insufficient grounds for federal jurisdiction. The Fifth Circuit affirmed remand orders but sent cases back for reconsideration under a new legal standard. District courts again granted remand motions. The companies appealed again. The Fifth Circuit ultimately held that companies failed to satisfy the acting under requirement in most cases. But in these particular cases, a divided panel ruled differently. The majority found the company satisfied the acting under requirement through their World War II aviation gasoline contracts. However, the panel split on the relating to requirement. The majority held that crude oil production was unrelated to aviation gasoline refinement. Why? The contracts contained no explicit directive about oil production activities. The majority found the federal crude oil allocation program severed any connection by allowing companies to purchase crude on the open market. Judge Oldham dissented. The dissent argued that as vertically integrated companies, the oil companies' crude production was inherently connected to their federally mandated gasoline refinement. Disrupting crude production would have hampered the federal interest in refined aviation gasoline explicitly outlined in the contracts. The oil companies argue the Fifth Circuit created an impossible standard. The companies contend requiring explicit directives conflicts with Supreme Court precedent demanding liberal interpretation of federal officer removal. The standard should focus on whether activities connect to federal duties, not whether contracts contain specific language. The oil companies claim a circuit split exists. The Third Circuit's Commonwealth's motion case found the relating to requirement satisfied without requiring explicit contractual directives. The Fifth Circuit now demands explicit language. Louisiana parishes push back hard. The parishes argue the majority opinion was unpublished and fact-specific, not establishing any categorical rule. The Third Circuit case involved different circumstances with explicit federal delegation. The parishes contend petitioners failed to show sufficient nexus between crude oil production and refinement contracts. Both cases raise fundamental questions about federal court access for constitutional claims. The first choice case asked whether state investigations can effectively immunize themselves from federal constitutional review by using non-self-executing subpoenas. The Chevron case asked how connected private conduct must be to federal duties to justify federal court jurisdiction. The Supreme Court's decisions will determine whether climate litigation stays in state court, where plaintiffs prefer to litigate, or moves to federal court where defendants typically fare better. Every pending climate case may be stayed pending these rulings. The court granted certiorari in both cases, suggesting at least some justices believe the lower courts erred in ways requiring Supreme Court intervention. The decisions could reshape how government investigations proceed and where major environmental litigation gets decided. Both cases will likely be argued next term, with decisions expected by June 2026. The outcomes will influence constitutional litigation strategy and environmental law for years to come. We'll continue to monitor the cases and will of course provide additional analysis as the cases get closer to oral argument. Thanks for listening to today's episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Talk to you soon.